Yes.
There is a lot. Item 5, it is for admission. It is a fixed matter.
Item 5, yes.
I have instructions to appear in this case, Lordship, so I need 3 weeks' time.
For the respondents.
No, for the petition.
Yeah. Okay. Learned Senior Counsel, Mr. Sidi Jamir, submits that he has received instructions to appear on behalf of the petitioner in the present case, and accordingly prays for 3 weeks' time to file his Vaklatnama and to receive further instructions. So,
May I please?
Learned Counsel,
Relative.
yes. Yes.
Sorry to interrupt, Your Ladyship. Your Ladyship, here we are the conducting counsel. However, the petitioner has taken a brief from my, to that effect, we have issued our NOC. And then, as such, if I may be allowed to withdraw our Bagalanam, the present conducting counsel.
In the meantime, Mr. James Newmy submits that they were the counsels for the petitioner earlier. However, the petitioner has obtained the NOC from the present counsel. So, and he therefore prays that he may be allowed to withdraw the Vaklatnama. So, praise the Lord. List after 3 weeks. And CGSC, who's appearing? Learned Counsel, Mr. Sanisach, appears on behalf of the CGSC, Mr. Yangarwati. Yes, after 3 weeks.
Item 6, Lordship. In terms of the order dated 7/4/2026, this matter has been fixed today. And on that day, there was an IA to be considered. That was for the interim stay. But then, on the submission of the counsel for the respondents, instead of considering the interim, why not we go for the instant hearing? So parties have agreed to hear the matter expeditiously, and today is fixed for hearing the matter. Meantime, they were given 2 weeks' time to file affidavit in opposition. They have filed. So I need a short time to file reply to their affidavit in opposition. And may I pray that the matter may be fixed on 27th, that is Monday.
Okay. Learned Senior Counsel for the petitioner, Mr. Sidi Jamir, submits that the matter has been listed today for consideration of the IA.
No, Lordship, for hearing.
Oh, for hearing of the IA.
No.
For
The
hearing
main
of the main petition.
Yes.
Okay. For admission hearing of the main petition. However, the respondent number 4, is it number 4?
All the respondents.
All the respondents have filed their counter affidavits, and he wishes to file a reply to the same. Accordingly, he prays for listing the matter on 27/4 for admission hearing.
Lordship.
List on 27/4 as prayed for.
Meantime, I may be allowed to file
Mr.
reply
Dennis
affidavit.
Fletcher for the respondents. Who is appearing for the government?
It is Nagaland Legislative Assembly,
Oh,
Lordship.
okay.
I am preparing for respondent number 1.
Mr. TB Jamil for respondent number 1. Learned Counsel, Mr. Takamasa for respondent.
Respondent number 4. Highly advised.
Yes.
Lordship, to mention item 9 of the hearing.
Item 9.
Yes, sir. Lordship, I have certain difficulties today. I'm here, pray that the matter may be listed day after tomorrow.
On what ground?
Lordship, I have certain difficulties.
Okay. Then next week. Learned Counsel, Mr. Apo Ponganar, appearing for the petitioner, submits that he has some difficulties today. So, and prays for listing the matter next week. So, Learned Counsel for the respondents, Mr. Such and such, Learned Government Advocate, Mr. N. Longcombe is present. List after a week. Okay.
All right.
May I please, Your Ladyship?
Hmm.
I'd like to mention item 1 on behalf of additional AG in Team Song.
Hmm.
We pray for 3 weeks to file an affidavit in opposition.
Item 1.
Extend you.
Who's appearing for the petitioner?
Extend you.
Yes. Learned Counsel, Ms. Minoseno is present for the petitioner. Learned Government Advocate, Mr. M. Longcomer, prays for 3 weeks' time to file the affidavit in opposition on behalf of the learned additional AG, Mr. M.T.M. Song. So, any objection?
Yeah, Your Honor,
Yes.
my name may be reflect in next. I was for responding of a
R5.
panel of what's in National Bank.
You have filed your baklat nama?
Yeah, Your Honor, I'm
Okay.
for the
Okay.
bank.
Mr.
Respondent
Alan
five.
Kame appears for the respondent number 5. Your name is not there, no? Respondent number 5. So the registry is also directed to reflect the name of Mr. Alan Kame Rome as counsel for the respondent number 5 in the costas. List after 3 weeks is paid. Yes.
Right. Almost.
May I please, Your Ladyship?
Yes.
I beg to mention hearing item 10 and 11, it's an analogous matter. And appearing in item number 11, I've taken consent of the opposite parties and the parties concerned would like to take up this matter on 23rd. If this, Your Lordship.
Not possible. Maybe next week, because this week is my last week here and I've got lots of pending work, may not be able to finish it.
Lordship, otherwise it's a short matter only.
Short matter, like what? Compassionate appointment?
No, I'm challenging my termination order.
That may not be very short. Learned Counsel, Mr. Aliba Ozakam, appearing for the petitioner in item number 11, okay, in WPC 52 of 2024. On what ground? You're praying?
Lordship, otherwise the counsel for the government is preoccupied today. Otherwise, we were ready to take it up today.
Submits that he has some difficulties today and prays for listing the matter next week. Just say next week. List next week as prayed for. Mr. Moa Jamir appears for the petitioner in WPC 73 and the learned government advocate. Oh, government advocate has problems. Okay.
Yes.
So the learned government advocate, who's the
Enangami.
Enangami, senior government advocate Enangami has some difficulties today. So accordingly, list the matter after 1 week. Yes.
May I please, my ladyship?
Hmm.
I beg to mention item 3. Here I'm here to file my reply to the affidavit filed by the respondents. No, I'm granted 2 weeks time, my lady.
Reply.
Reply. So the affidavit filed by the
Counsel for
respondents.
Petitioner, Mr. Fosico Forte submits that he has received the affidavit in opposition from the respondents and would like to file a reply to the same. Accordingly, he prays for how much time?
2 weeks.
2 weeks time to file the reply. So prayers allowed, list after 2 weeks.
Reply.
Learned Government Advocate, Mr. Moa Imchin is present. Learned Counsel, Miss.
Not yet.
Oh, okay, not in this case. No, but.
Government has not filed the affidavit.
Okay. Learned Counsel, Learned Senior Government Advocate, Mr. Moa Imchen also prays for 2 weeks time to file his affidavit in opposition. So Learned Counsel, Miss such and such appears for respondent.
Private respondent 3 to 6.
Respondent 3 to 6. So yes.
I'll reply, my lady.
Hmm.
Mr. Ladyship,
Hmm.
I beg to mention item number 8.
8.
Yes, Your Honor.
Yes.
With consensus prayer of all the parties, this matter may be fixed for hearing after 3 weeks.
Learned Counsel, Miss, your name?
Lorena.
Loreno, his mentioning on behalf of the leading counsel, Miss Nityo Koza, and also with the consent of the opposite parties, prays for listing the matter after
3 weeks.
after 3 weeks. Stop. List after 3 weeks as prayed for. And the names of the private respondent number such and such and additional AG. Yes.
2
Okay.
For motion from the supplementary clause list, item number 16.
Judicial edition. Your Lordship, this instant petition is seeking for commissioner appointment. The petitioner, late father, was serving as a voluntary worker under CMO office. While serving for more than 26 years, he died on harness on 26th of June 2024. And thereafter, he submitted his application dated 15/12/2024, which was duly forwarded by the CMO worker to the Directorate Health and Family Welfare. It's in annexure number 5, page number 21, where it has been stated about the orphan status of the petitioner. The petitioner late mother predeceased on 2012, leaving behind the petitioner wholly responsible for his 4 siblings along with him, Your Lordship.
The instant writ petition has been filed by the petitioner seeking a writ of mandamus directing the respondent authorities to consider and appoint the petitioner on compassionate ground in terms of the office memorandum number AR-8/8/78 dated 17/9/2015. Stop. Heard learned counsel for the petitioner, Ms. Shisa Jamir. So it is stated that the petitioner's father died in harness on 26/2024. So the petitioner thereafter submitted an application dated 15/12/2024 seeking appointment on compassionate ground. However, despite the lapse of a considerable period of time, the said application has not been considered by the respondent authorities. So, being aggrieved, the petitioner has come before this court. So, the issue notice returnable in 4 weeks. Learned Government Advocate Mr. M. Longkamar has accepted notice on behalf of all the respondents, hence no further formal notice is called for. So the petitioner shall, however, supply extra copies of the writ petition on the Learned Government Advocate during the course of the day. So list after follows.
For motion, item number 17.
Same, compassionate.
Your Lordship, in this case, the petitioner is at serial number 1. And the respondents ought to have considered the case of the petitioner, but without that, here at annexure Chi, Your Lordship, this is a recent notification. Here, 1,092 candidates were selected out of 1,176 posts advertised. So there are still sufficient number of vacancies available. Even if it is not available, the state respondents ought to have considered the petitioner against one of these vacancies.
You had approached this court earlier.
Yes,
What was the direction?
the direction was to consider the case in terms of the poem. And then accordingly considered, the list was compiled, which is at.
Taken by the state respondents pursuant to this order shall be intimated to the petitioner.
Yes.
So has it been intimated to you?
Yes, now at annexure F, Your Lordship,
Hmm.
this is the annexure F.
If
Here the petition, they have compiled the
okay.
list of applicants. So the petitioner is
Serial number 1
one.
since 9 September 2025.
Here the petitioner's father
Yes.
expired in 2017.
2017.
2017, and then his representations were not considered, so the petitioner was compelled to approach this honorable court.
You consider
And-
appearing? We'll issue notice on the
Yes,
next
Your
date. Maybe we can dispose it of. You get
Yes, Your
instructions because there seems to be vacancies also, and he's at number 1.
Yes.
By filing the instant writ petition, the petitioner has come before this court praying for a direction to the respondents, to the respondent authorities to appoint him on compassionate ground. So, Lord Learned Counsel for the petitioner, Mr. Tongpo Pongoner. So, it is the case of the petitioner that the petitioner's late father died in harness on 29/8/2017. Leaving behind the petitioner's mother and the petitioner and 2 sisters as dependents. Stop. Upon the demise of his father, the petitioner submitted an application for appointment on compassionate ground. Stop. Thereafter, the petitioner filed another application dated 22/9/2021. Stop. As the petitioner's applications remained unconsidered, the petitioner preferred a writ petition being WPC 5/2022, which was disposed of by this court on 27/1/2022, with a direction to the state respondents to consider and dispose of the representation of the petitioner dated 22/9/2021 within a period of 2 months from the date of receipt of the order. Stop. Subsequently, the respondents have issued a detailed list of applicants on the ground, a detailed list of compassionate ground applicants in respect of Dimapur, and the petitioner's name figures at serial number 1 of the said list. Stop. It is also the contention of the petitioner that in the meantime, the state respondents have published a notification dated 13/4/2026 recommending appointment of 1,092 candidates to the post of constable under bracket GD in the police department. As per the notification, altogether 1,176 posts were advertised, but only 1,092 candidates were recommended for appointment, implying that 84 posts are still available as vacancies. Stop. However, the petitioner's case has not been considered till date, in spite of being at serial number 1 in this list. Stop. The petitioner has therefore approached this court praying for relief. Stop. Issue notice returnable in 4 weeks. Stop. The learned government advocate Ms. AIME has entered appearance on behalf of all the, has accepted notice on behalf of all the respondents, and therefore no formal notice is called for. So the learned counsel for the petitioner shall supply extra copies of the petition on the learned government advocate during the course of the day. So it is further directed that the learned government advocate shall obtain instructions on the next date, and an effort shall be made to dispose of the matter. Okay. Please, Dr. Forbes.
For admission, item number 2.
Please, Your Ladyship.
Yes.
Parties are ready for disposal of this case.
Okay.
This is the third round of litigations. The matter relates to land ownership.
Regarding land
Right.
ownership.
But then, with due respect, the outcome of this writ petition may have a bearing in the other land ownership issues, because before I go to the issues, we kindly appreciate the fact that in the last 10 years, this honorable court, with regard to land ownership, has been given 2 types of directions. One direction was to strictly appoint in terms of the OM. The other direction is to conduct an interview. To conduct an interview, keeping in view the OMA TV judgment and all that.
Yes.
So that way, Lordship, it has not been consistent on. Now, in this case, this honorable court gave a direction that to give preference to the land ownership if they are found eligible. But when the interview was conducted, it was strictly decided selected candidates were strictly selected on the basis of merit, without any consideration
For the landowners, without considering the.
Yes, without considering the land ownership. That is the issue. So if that is upheld, then the OA itself will become redundant, because for land ownership, if interview is conducted, then if this judgment is this decision is upheld, then irrespective of whether landowner or not, somebody will be selected strictly on the basis of merit in the very OM. The policy of the will become a dead letter. That is the sums and substance of the case. But since there are two rounds of litigations before I come,
So
the-
the earlier petition, the direction was given to.
initially,
Ah,
first direction was, it was a backdoor appointment. So we came before this honorable court, and this honorable court set aside the backdoor appointment with a direction that proper interview be conducted in terms of the office memorandum, standing office memorandums. That was the direction.
Okay.
Then an advertisement was issued. But in the advertisement, Lordship, thereafter, Lordship, the advertisement was issued at page 67. Now, in this advertisement, it is on the eligibility criteria, it is totally silent about the land ownership. So we approached this honorable court at page 68. Then, Lordship, at page 73, condition number 7. Amongst other conditions regarding eligibility, that the landowners or their family members shall be given preferential treatment if otherwise find eligible for appointment.
At page 73.
Yes, the advertisement, which was in compliance of the judgment of this honorable court, purportedly. Condition 7.
Condition 7. Okay.
Then your lordship may kindly see the minutes of the interview. Lordship at page 157.
Minute, okay.
Above the names, the following candidates has been selected on merit basis, 157. Above the 5 names,
Page
157,
157.
annexure 30.
Oh, yes. Meeting minutes.
Yes, the following candidates has been selected on merit basis.
So the landowner is not there.
Yes, actually, in the affidavit of the state government also, they have taken a categorical stand that the appointment, that the selection was strictly on the basis of merit.
Merit.
So that is the issue. That is the issue involved. We have to balance the issue. Otherwise, if merit is upheld, the selection should be strictly on the merit. Then the very office memorandum will become redundant in the direction of this honorable court. So that is the issue involved here. Lordship, kindly allow me to give a brief background before I'll be dwelling on the two judgments of this honorable court. So the only issue will be the interpretation of the two judgments, and there were earlier two other judgments which has been reflected by the court and the bench in the judgment of this honorable court. I was referring to that.
Regarding the same petitioners.
Yes. Lordships regarding the same petitioners and other petitioners, which is reflected, because this is the same petitioners are approaching this honorable court for the third time.
Okay.
So the two judgments are my petitions only. The only thing is, one of my co-petitioners in the recent interview was selected on merit. But since he is a landowner, we have no grievance against him being one of us. Being a landowner, we have no challenge his appointment. In view of the fact that he was a landowner, he's a landowner, and he was co-petitioner in the two round of litigation. That I will highlight when I go to the judgment. Lordship.
No, but how many landowners can be appointed? Only one can be appointed.
No, there were 4 vacancies.
No, even if there are 4, as per the scheme, only one can be
Because
appointed.
for different posts, there were multiple landowners.
Okay.
There were multiple landowners. So that issue has already been settled by the earlier round of litigation. Lordship, at page 1, at page annex 34A and annexure 1 and 34 and page 38, annexure 1 and 2, Lordship, the parent villagers.
Deed of agreement.
The parent villagers has donated more than 1,000 hectares of land for establishment of parent district headquarters. And that time there was an agreement entered that for any 4th grade appointment, preference should be given to the landowners. Now here, the issue is relating to the Manot. The issue relates to, Lordship, the fourth grade appointment in Parian District Hospital. So, my lord, I will, when I read the judgment, it all will be reflected. So, just for reference, because this has been dealt with in the earlier 2 round of litigation,
Then
call for your satisfaction.
Let's see the judgment then. No.
My lord, before that, kindly allow me to quickly send the agreement. I would like to show 1-2 paragraphs of the notification
this
so that
agreement.
to save time.
Okay.
Now, my lord, 16 August 2018, the office memorandum, no issue. Then, lordship may come to page 45. By an office memorandum 7 December 2016. This is the procedure for filling up grade 4 post. Now, at condition number, only an indigenous inhabitant to be appointed, and at condition number 2, your ladyship may kindly see the constitution of the board. Number 3 is representative from the director of the department, representative concerned of the administrative department, then PNR department and senior officer. This is the prescribed member for constitution of the board. Then, lordship, initially, in view of the vacancies, the petitioners, several petitioners had applied. And lordship, at page 49, the typed copies. On 14 September 2020, this is the direction by the principal director in reference to the subject cited above. I am forwarding here with 4 applicants who are applying for the post of medical attendant in district hospital against the vacancy caused to the retirement of such and such. The verified landowner, local candidate, as per enclosed pioneer memorandum and land revenue notification for ready reference. It may also be stated that the following are the criteria during the sitting for selection committee identified the real landowner affidavit agreement. Then candidate selected for maybe forwarded to the government for approval. So this is the standard procedures in terms of the owing. Lordship, we can appreciate this is the standard procedure in terms of the OM data 16/8/2018. Page 42 is a standard, is the OM of the policy for appointment of land ownership. So whenever land ownership has to be appointed, this is the standard procedure. My lord, at page 50, the petitioner number 1 was also one of the applicant at serial number 2 at that time.
Okay, this is the petitioner 1.
Number 1. However, lordship, instead of considering your cases, when the process for appointment on the basis of the OM was under process, the respondent authorities appointed 4 respondents through backdoor. So we approached this honorable court in WPC 19/2023, page 51. My lady may kindly appreciate the fact that that 5 writ petitions were filed, WPC 19, page 51. WPC 19 was filed with the present petitioner number 1, at page 51. Then at page 52, WPC on the top, WPC 22 was filed by petitioner number 3, the present petitioner number 3.
Okay. This is petitioner 3. The first one is petitioner number
Petitioner number 1. Then below it, on the bottom of 52, WPC 20
WPC 20.
is filed by petitioner number 2. Present petitioner number 2. Then at page 53 on the bottom,
WPC 21.
21 was filed by present petitioner number 3. Then at page 54 on the bottom, 23 was filed by the present petitioner number.
Wait, WPC 22 was petitioner 3. WPC 22. 22 of 23.
WPC 22 was, kindly bear with me, petition, yes, WPC 22 was petitioner number 3.
Then WP 21.
WB 21 was filed by one of the co-petitioners who is recently selected.
Oh, okay. Already selected.
Already selected. Then, Lordship, the
That
commission,
WB
everything is given a page 4, paragraph 4, page 56. It is the case of the petitioners that the parent township was established in 1947 with the territory of Old Parent Village. The Old Parent Villages donated land measuring over 400 acres free of cost without any compensation, with a verbal agreement with the state government that all the grade 4 occupants should be given to the parent villagers during the establishment of the government departments. According to the petitioners, their land was also included the land donated for the establishment of township. Thereafter, a written agreement was signed between the district administration and the all parent villagers when the parent town was established. Township was extended on 12/5/1995. It was agreed that no land compensation shall be paid to the landowners, but in lieu of land compensation, a commercial plot of land measuring 50 by 60 shall be allotted to the concerned landowners who are having their own land within the town land extension area, and the preference shall be given to the landowners for the appointment to the grade 4 posts as in and in the allotment of contract works. The date of agreement was modified on 23/11/1998, providing that the agreement covered all the government establishment departments established in the parent district headquarters since establishment in the year 1947. The petitioners contended that primary health center was established in the parent in the year 1958 and it was upgraded in the year 2003. Thereafter, the community health center was upgraded to district hospital in the year 2006. According to them, in spite of initial verbal agreement in the year 97 and the date such and such, all the grade 4 appointments made in the Department of Health and Family Welfare since establishment of the Parent Health Center in the year 1958 in Parent was not from amongst the land, was not from amongst the landowners. In other words, appointments were not on the basis of land ownership. The Lordship may kindly allow me to come to paragraph 18, page 64.
Yes.
The petitioners in the instant cases have relied upon OM Data 16/8/2018, where in the manner of consideration for providing employment to landowner have been provided, and also with the clarification that such employment cannot be provided in perpetuity. From a perusal of the imbued administrative approval Data 17/1/2023, it is seen that some sort of communication has happened between the state government and the Directorate of Health and Family Welfare. However, there was no documents on record to show what has transpired leading to such communication. All that is stated in the counter affidavit of the state respondent is that the previous respondent number 4 has also applied for appointment against the grade 4 post in question and being qualified and eligible. His candidature was approved and convened accordingly for appointment via the letter dated 17/1/2003. There is no mention after fact that the case of the other eligible candidates, including the petitioner, were also considered. Therefore, upon due perusal of the materials available on record, this court finds no material to support and uphold the imbued administrative approval dated such and such. It is also not the case of either of the parties that an open advertisement for filling up the grade 4 in question has been floated and the process of verification and selection was accordingly initiated. It is the case of the petitioners that they have submitted their respective applications, which is one cases 1923 was in the process of being verified in terms of the government instruction reflected in the Indian communication. As the government instruction issued from time to time through office memorandums, the indigenous inhabitants of the district concerned and also landowners are eligible to be considered for appointment to grade 4 posts, and for making such consideration, proper screening and verification is required to be done by the Deputy Commissioner of the district. Such process is not discernible in the instant writ petitions. Even in the case of the WC 1923, only 4 persons appear to have been mentioned for consideration. The consideration in the considered view of this court should be made open to all concerns, including the private respondents in this writ petition. Thereupon, upon due consideration, the administrative approvals that is 17/1/2023 in the appointment of the private respondent number 4 in all the writ petitions are found to be non-sustainable in law and they are accordingly set aside. The state respondents shall now initiate a fresh process for filling up the vacancies in grade 4 posts in the district hospital parent by inviting applications from all interested and eligible persons to apply for the same. The Lordship may kindly take note of the word applicants from all interested and eligible persons, because eligible is the issue of dispute here. I'll come later. The applicants are therefore screened and their names verified in terms of the standing guidelines. Lordship may can take note of the word the standing guidelines issued by the state government shall be a shortlisted for appointments, since it will be in the interest of public that the vacancies are being filled up at an early stage. The state respondents are directed to complete the entire process within a period of 3 months. So direction at paragraph 20 is that all interested and eligible person to apply in terms of the standing guidelines. Standing guidelines are inclusive of the 2 notification guidelines, which I have shown the 2018.
Yes, yes.
Then purportedly, Lordship, at page 67, and now we're coming back to the advertisement as issued. In pursuance of the government of Nagaland held in welfare dated 12 July 2024, the applications for indigenous inhabitants of the district are hereby invited to fill up 5 posts of grade 4 posts as shown below the establishment of the medical superintendent district hospital parent. This is in compliance of the Honorable High Court judgment dated such and such. Then serial number 1, medical attendant, 3 posts, multitask, 1 post, lab attendant, 1 post. The applicant should be an indigenous inhabitant of the concerned area as per the 26 October 27 notification. Lordship, the age of the candidate should not be less than 18 years. Candidate should be at least class 5 passed. Applicant should reach the directorate before 23rd August. Interview shall be held in the district Directorate of Health and Family Welfare on 28 August, starting from 10 a.m. The candidates are hereby directed to bring the following document in original: NOC from the respective village council ward, indigenous inhabitants certificate, scheduled tribe certificate, academic documents, birth certificate. Incomplete document shall be summarily rejected by the board. No separate calling letters will be issued. The selected candidates' result will be notified in the local dailies. We challenge this notification again on the ground that it is not in conformity to the direction of this honorable court, because it is totally silent about the office memorandums. Office memorandums.
All these 5 posts are grade 4.
Yes, all there are 5, grade 4. Then, my lord.
So you filed 160.
Yes, so we filed 160, page 68. Now, your ladyship, at page 68, serial number 2. Page 68, serial number 2 now. He is the one who is already selected. So kindly allow me to read the judgment 21/11/24. Page 69 from the bottom, last line. I am reading it is a background number 371A and all that. I am not reading that. This court in WPC 1/22/2019 pass a direction stating that whenever state publishes any advertisement inviting applications for providing grade 4 posts, it has to be mentioned in the advertisement itself that landowners or their family shall be given preferential treatment. Thereafter, on one occasion, the state published an advertisement on 21/6/2024 inviting applications for filling up a post of medical attendants in PHC Chare Tuensang. In that advertisement, it was not mentioned that landowners or their family members who donated land shall be given preferential treatment at the time of selection. Therefore, WPC 1/23/2024 was filed challenging that said advertisement. During pendency of the said writ petition before this court, the Principal Director, Health and Family Welfare, Nagaland, had admitted the aforesaid lapse and agreed to have a corrigendum in respect of the said advertisement dated 21/6/2024. On that ground, the writ petition was disposed of. My ladyship, these judgments were placed before this honorable court, the 2 judgments at that time of hearing. And according to my information, in terms of the advertisement, corrigendum advertisement was conducted, advertisement was issued, and appointment was made giving preference to landowners by the same medical department. These two judgments which I have referred to. So this was relied upon before this honorable coordinate bench of this honorable court. Now the state respondents publish an advertisement dated 7/7/2024 without mentioning the policy that landowners or their family members shall be given preference. This is the reason why the present petition has been filed. I have considered a submission made by the Learned Council of both the sides. It is an admitted fact that landowners or their family members who have donated land to the government get preferential treatment if otherwise found eligible for appointment in grade 4 posts. The state respondents did not mention that fact in the imbued advertisement, it should have been done by the state respondents. Therefore, the advertisement dated 7/7 such and such is bad and low and therefore stands quashed. Accordingly, the state respondents are directed to publish a fresh advertisement where it shall mention amongst other conditions regarding eligibility that the landowners or their family members shall be given preferential treatment if otherwise found eligible for appointment. In the present writ petition, the petitioners have already completed 35 years of age. Therefore, they pray for direction that the upper age limit should be relaxed to them only. To that effect, the petitioners have pointed out that by the notification dated 15/10/2024, the government of Nagaland has already made the upper age limit to 27 years. Submitted that no order is required to be passed in that matter in view of the aforesaid judgment. With that, so my lord, the operative paragraph, these last two paragraphs.
Yes.
Now, thereafter, page 73.
Then they issued this page 73.
Yes. So, purportedly in compliance of the judgment of this honorable court, the advertisement was issued. Lordship, you kindly see on the top, just below the advertisement. Government of Nagaland application for indigenous inhabitants of districts are hereby invited to file 5 posts of grade 4 as down below under the establishment of medical superintendent parent. This is in compliance with the Honorable High Court judgment dated 26/11/24 passed in 160. So it was issued purportedly in compliance. Now, the other eligibility criteria is same with the previous advertisement. Only the additional eligibility mentioned is condition 7.
Only serial number 7 or
7, yes. That amongst other candidates regarding eligibility, that the landowners or their family members shall be given preferential treatment if otherwise found eligible for appointment. Now, Lordship may kindly see with regard to at page 78. An RTI application was filed on 2/5/2024. Married.
Yes.
Questions. When the primary health center was established in Baden Town and finally upgraded to the district hospital, how many persons were appointed to grade 4 posts under the establishment of till the upgradation? How many persons were appointed on grade 4 posts on landowner basis since the establishment of BHC till upgradation to district hospital? Kindly furnish all the appointment order along with the supportive documents. Then reply was given. Lordship, at page 80. This is the RTI reply on 4th April 2024. And page 81. Reply to query number 3, nil. So, forfeit appointments has been made over the years, but nobody has ever been appointed till 2024 on the basis of land ownership in terms of the RTI reply. Now, coming to the imbued orders at page 30, 157. Page 157. Kindly allow me to read. The Department Selection Committee for interview on 26 March 2025 at NHP conference for appointment of 5 grade posts under medical superintendent, 3 posts of medical attendant, 1 post of MTS, 1 post of lab attendant with the following members: additional director, joint director, deputy director, registrar. My lady may kindly take note of the OM dated 7/12/2016 at page 45, the constitution of the board. Page 45. Page 45, paragraph 2.
This is for filling up grade 3 and 4 posts.
Yes. I have taken a categorical stand in paragraph 17 that the appointment was in violation of the standing guidelines of the government. Now here, the following candidates have been selected on merit basis. This is in compliance with Honorable High Court judgment order dated such and such in 160/2024 and with government approval for readvertisement by interview dated such and such. The following candidates have been selected on merit basis. Selected on merit basis. That may kindly be take note. And serial number 5 is my co-petitioner in the 2 round of litigation. So we have my challenge. I am challenging the recommend selection of 1, 2, 3, 4.
Yes.
Then, Your Ladyship, the marks scored by the marks scored by the different candidates. Lordship, kindly allow me that at page 158, serial number 11. Page 158,
Yes.
serial number 11. That is respondent number 10.
Respondent 10.
Then at
8.
158, serial number 11.
Is respondent number
10.
10.
Then next page, serial number 30. Page 159, serial number 30, respondent number 11.
Respondent number 11.
Then page number 161, serial number 63. Serial number 63, respondent number 9. Then Your Ladyship may go to page 165. 165. Serial number 129, petitioner number 1. Serial number 130, petitioner number 4. And serial number 131 is my co-petitioner K.A. Keting, whom we are not challenging, who is selected. Then my ladyship may go to page 167, serial number 20. Serial number 20, petitioner number 3. Then at serial number page 168, serial number 17, respondent number 8. Then next page 168A, the last serial number 23, type copy will be on the next page. Type copy is in the next page. Last line 23.
Serial 23.
That is petitioner number 2. So that is the marks scored. Then, Lordship, next page 169. The envision letter dated 15 May 2025. This is a letter submitted by this is a administrative approval. In inviting a reference to the subject cited above, I am directed to convey the approval of the government for selection of 5 candidates on merit basis for appointment on the various posts of grade 4 under medical superintendent, therein subject to constant conditions by the government. The serial number 1 to 4 unchallenging, 5 is my co-petitioner, so strictly on the basis of on merit basis. Then next page, the impugn letter order notification on 2/6/2025. Selected on merit basis. Selected on merit basis is on the third line from the top. My lady may kindly see the last slide, paragraph. This is in compliance to the Honorable High Court judgment order dated 29 November 2024, passed in WPC 160. Then thereafter, the individual appointment orders has been issued from what page 172, 172, 173, and 174. Order dated 13 June 2025 are the appointment order of the private respondents, the same date of appointment 13 June 2025. The last order 175 is the appointment of KA Catering my co-petitioners.
The landowner.
Yes. Now, Lordship, kindly allow me that it was purely an oral interview. No written exam, only oral interview was conducted. Kindly allow me to refer to paragraph 6 to my writ petition.
Yes.
That in compliance to the order dated 26/11/2024, passed in WPC 160/2024, the principal director had issued the advertisement dated such and such. My lady may kindly take note of this line. The eligibility criteria and condition are as follows. The eligibility criteria and condition are as follows. My lady has seen it, so I'm not repeating it, up to 1 to 7. To this government's reply, at paragraph 5 of the government's reply, government's affidavit, page 2.
Page 2,
Paragraph 5.
paragraph 5.
That as regard the statements made in paragraph 4, 5, and 6 of the writ petition, the same are matter of records, and therefore the answering deponent offer no comment. However, the statements that are contrary to and inconsistent with the record shall be deemed to have been denied by the deponents. So it is not denied the fact that the 7 conditions are in the advertisement dated 26/11. Advertisement is the eligibility criteria admitted by the government. My lady may come to paragraph 9 to my petition. That it is respectfully stated that the oral interview was held on 26/3/2025, where the petitioners had appeared. The interview board had only asked very simple general questions. These are the questions asked by the interviewers to the petitioners that I'm not reading. Then next page. Last paragraph, it is respectfully stated that none of the board members had inquired or asked as to whether the petitioners are genuine landowners who had donated their land free of cost for establishment of the district hospital, and no facility whatsoever has been extended to the petitioner's family as landowners. My lady may kindly kindly see the reply of paragraph 5, which my lady has just seen. Page 2.
Yes.
4, 5. So the conduct of the interview board members not denied, that they have not inquired about all that. My lady may kindly appreciate the fact that the examination board members also made respondents here.
Okay.
Then my lady may kindly refer to paragraph 17 to the writ petition. Page 25.
Yes.
Merit. That the petitioners respectfully submit that in the peculiar facts and circumstances as stated above, it is respectfully stated that when the petitioners appeared to oral interview on 26/3/2025, they were under the full impression and belief that the interview board will be conducting strictly in accordance with the standing guidelines, orders of this Honorable Court, and the conditions stipulated in the advertisement dated March 2025. It has come to the knowledge of the petitioner that the interview board and the respondent authorities had acted in clear violation of the standing guidelines, orders of this Honorable Court, and the conditions stipulated in the advertisement dated March 2025. Only after they obtained the detailed information through RTI reply dated 19/6/2015. As such, the present petition is not a case where the petitioners, after appearing the interview willingly and being unsuccessful, is challenging the interview result as an afterthought. It is humbly submitted that this legal principle shall not be applicable in the present case. Now, my lord, my respectful submissions. These are that is the facts of the case. Unfortunately, my lady, kindly allow me to read a paragraph from the government's affidavit. Paragraph 9, but kindly allow me to read from page 5. Paragraph 5. Paragraph 9 of the government's affidavit. Paragraph 9, but I'm reading from, it's a lengthy paragraph, to save time, I'm reading only paragraph 5. Page 5, I'm sorry. Page 5. The state respondents from there.
The state respondent thereafter.
Yes. Kindly allow me to read till the end. The state respondents thereafter constitute a departmental selection committee with additional director as chairman of the committee, along with 3 other members. As stated in the advertisement, the interview was conducted on 26/3/2025 by the departmental selection committee, and basing on the marks obtained by the applicants, the successful candidates were selected. The answering deponent further respectfully states that though this Honorable Court, by its order dated 21/11/2024, directed the state respondent to publish a fresh advertisement by mentioning that the landowners or their family members shall be given preferential treatment if otherwise found eligible for appointment. This Honorable Court, by the order dated 26/11/2024, did not alter or change the direction issued in 12/2/2024, and thereafter only the additional conditions regarding the landowners were added in the fresh advertisement dated March 2025, and the rest of the conditions remains the same. The answering deponent also respectfully states that on perusal of the order dated 21/11/2024 of this Honorable Court, it is a clear direction that the landowners or their family members shall be given preferential treatment only if they are found eligible for appointment, which means that in case of general candidate and a landowner candidate would be eligible for appointment, then only preferential treatment would be given. Kindly pause here for a moment. My lady, since all of us were found eligible, we were called for interview. Because Lordship, selection and merit and being eligible to appear for the interview are 2 different issues. Kind of in the direction of this Honorable Court is that if the landowners are found eligible, then give them preferential treatment. Because my lady may kindly appreciate the fact that a landowner may not be overage, he may not have the requisite qualification, things like that. The preferential treatment, as mentioned by this Honorable Court, cannot be interpreted as even if a candidate applicant who is landowner and after miserably failing in the interview, yet on account of he or she being a landowner, preferential treatment should be still be given to him or her, and he should be selected and appointed against the vacancy. As seen from the interview scope sheet held on 26/3/2024, the previous respondent has better performed than the petitioners by scoring better marks to them. The answering deponent also further respectfully states that it is only after appearing in the interview and without any complaint and miserably failing in the interview, the petitioners has filed the present writ, making an allegation that decision of the recommendation of the court is in clear violation of the Kohima dated 16/8/2018 and the orders of this Honorable Court, which is not tenable in the eye of law. It is also stated that it was clearly mentioned that the interview will be conducted on 26/3/2025, and in compliance of this condition mentioned in the advertisement, the petitioners has appeared to interview, and thereafter the petitioners have got no right to say that recommendation of the interview board and administrative approval only on oral interview is totally arbitrary and illegal. Hence, the contention of the petitioner that the meeting minutes of the Department Selection Committee held on 26/3/2025 is without any obligation of mine and in clear violation of OM dated such and such and such is out and out false and misleading, and this court is therefore denied. So this is their stand is that only if merit is equal, preference will be given. Now, subject to repetition, my lady, I'm stressing that it was only an oral interview. So it was only a personality check, nothing more, nothing less. So how merit will be determined when there is no written?
Yes.
So summing up my submission. Your ladyship may kindly take note of the fact that nobody is aggrieved by the office memorandum of 2016/8/2018.
1 minute. Portion set aside implements. Set aside the implementer. Portions are set. Set aside the implementer. Okay. Yes.
So, my lady, my first submission is the office memorandum 16/8/2018, but which policy has been let down. It is still holding the field. It is not the case that the petitioners are either the petitioner or respondents that this has been set aside or this is illegal. And the office memorandum 7 December 2016, the constitution of the port, nobody is challenging that. Purportedly, the interview was conducted in the line of that office memorandum. Thirdly, the direction of this honorable court. Firstly, WBC 19/23 by the judgment dated 12/2/2024. The direction of this honorable court was conduct the interview, making everyone eligible for all eligible person in terms of the standing guidelines. In terms of the standing guideline. In other words, Office Memorandum of 2016/24 standing guideline, conduct the interview. And since preference was not given, landowner condition was in terms of the standing guidelines, preference should have been given to the landowners. That was not stipulated in the advertisement, which was challenged. So in 160, WBC 160, this honorable court, relying on the two earlier judgments of the court and bench of this honorable court. My lady, may kindly.
Yes, we have seen just now.
Yes. So accordingly.
So relying on those, the court directed.
Yes, and my lady may kindly appreciate the fact that the judgment, one of the judgment which was relied upon by this honorable court is from the same medical department. Same case, and where we have acted upon and given, where we have acted accordingly. WBC 122 onwards.
123, WBC 123.
122 and 123, page 69 and 70 on the bottom. 69 was a direction, then 61, then 123 is specific to medical department. And it was the director himself who admitted that he had committed an error and corrigendum was issued.
No, but in this case also, they have reissued new advertisement.
That is the point. Thereafter, in terms of the advertisement, preference was given to the landowners.
In the earlier cases.
Yes. That's how this was relied upon. So my respectful submission My respectful submission, my lady,
Mm.
though purportedly the claims that the meeting minutes, in the subsequent impugned orders that it was done in compliance with the direction of this honorable court in WPC 160, in fact, it was in total contravention of the direction of this honorable court. So this honorable court, inconsistent with the other 4 judgments,
Mm.
I'm praying that that may be taken note of. And finally, most important, my lady,
Mm.
if the action of the respondent is upheld,
Mm.
then it will make the office memorandum of 2018 redundant at that letter. And it will have very serious consequences in sensitive state like Nagaland. Because tomorrow, if advertisement will be issued, interview will be conducted irrespective of, without any verification whatsoever, we can choose. And especially when it is only an oral interview. Especially when it is an oral interview. So that aspect, because unless this is, in fact, the respondent authority should have upheld and protected their own notification of
But
2018.
in other departments, they don't conduct interview for landowners.
Unfortunately,
Just on the basis of land ownership certificates.
Unfortunately, in view of this direction, that is why from day one, initially I was making a submission that this honorable court has not been very consistent in direction. On the one hand, as my lady has really pointed out, since it's a policy, mostly the
They just
direction
apply
was
and- yes.
point the landowners.
Yes.
But here, to balance the 4 judgments I'm relying upon, keeping in view the Omadivi judgment, with due respect, some honorable judges had passed such directions that conduct an interview, but if landowners are eligible, give preference in terms
Because
of
the
the
moment it is advertised,
Yes.
then all other candidates will also apply.
Yes.
Non-landowners will
Exactly.
also apply. Then this problem.
However, yes, that problem, but however, the condition given by this honorable court, that
Preference.
let everyone apply, but then if their landowners are eligible, give preference. But as clearly admitted by the respondents in the affidavit and from the interview reports, it was strictly on the basis of merit. Selection was strictly on the basis of merit. It is totally silent on land ownership.
Mm. Okay.
Now, so my respectful submission is to quash and set aside the impugned orders and give a direction to the respondents to appoint the present petitioners on the basis of land ownership. That is my prayer. Now, to supplement the point that the office memorandum by the action of this office, by wrongly interpreting the judgment of this honorable court, the office memorandum has become a dead letter. It is an unharmonious construction. Harmonious construction of interpretation of statutes. Just one paragraph, 2003 3 SCC 57. Paragraph 13 to 21 is a relevant paragraph, but I only read last paragraph. My lady may kindly go through from paragraph 14 to 21, but I'll read only one paragraph, 21.
Okay.
The provision of one section of the statute cannot be used to defeat those of another unless it is impossible to effect reconciliation winter. Thus, the construction that reduces one of the provision to a useless number or dead letter is not a harmonious construction. To harmonize is not to destroy. My respectful submission is that by the action of the government, they have already destroyed the notification, the office memorandum of 2018. Now it has become totally, it has, by their own action, they have totally make it redundant. They are saying, no land ownership, interview, strictly on merit. And when there's a direction by this honorable court and the meeting minutes, there is not a whisper about land ownership. In fact, when we appear with all documents, not denied by them, they have not inquired whether you are landowner or whether you have got any benefit, nothing. Totally silent, only merit. Well, much obliged.
Yes.
May I please, my lord?
Hmm.
Lordship, since my learned senior friends have taken my note to almost all the documents which I was like wanting to refer to. However, your lordship, for better understanding of my submission, allow me to take
Facts
yes.
you need not
Yes.
repeat.
No,
Yes.
just the
This on what ground?
no, just the decision given by the court and the interpretations of it, your lordship. Lordship, now as pointed out by my learned senior friend that a group of the batch of writ petitions was filed and then it was disposed of by a common judgment order dated your lordship 12/2/2024 and which your lordship will find it relevant page at page 65. Your lordship, para 19 and 20, but para 19, your lordship, I'll be referring only to one particular sentence, your lordship. That is sixth line from the bottom. It starts with D. 6 lines from the bottom.
Para 19.
Para 19. 6 lines from the bottom. That starts with D. The consideration.
Consideration.
I may be allowed to read this, my lord. The consideration in the considered view of this court should be made open to all those interested, including the private respondents in this writ petition. So this court took a considerations that it should be open for all, and the private respondent also should be given opportunity to apply and sit for the examinations. Then para 20, your lordship. This is the direction. The state respondent shall now initiate a fresh process for filing up the vacancies in group 4 post in a district hospital parent by inviting applications from all interested and eligible persons to apply for the same. From all interested and eligible person. Your lordship, no doubt. No doubt, your lordship. No doubt the court says that the application thereafter upon being screened and their claim verified in terms of the standing guidelines issued by the state government shall be shortlisted for appointment. No doubt that was there. But the first para itself is very clear that it should be an open advertisement, my lord. The first sentence, by inviting applications from all, your lordship. Now in compliance, your lordship. Yes, your lordship. In compliance with this honorable court order, we have the Director of Health and Family Welfare has issued an advertisement dated 7/7/2024.
Yes.
However, this was put under challenge again by the petitioners on the ground that there was no mention about preferential treatment.
Preferential treatment. Yes.
Yes.
Rightly so.
Yes. There was no mention about preferential treatment. Now, your lordship,
So the new advertisement.
the new writ petition was numbered as 160 of 2024. And this writ petition 160 of 2024 was disposed of by this honorable court through its order dated 26/11/2024. The relevant para, your lordship, page 70.
Yes, last paragraph.
Second last para. I may be allowed to read this, your lordship. Therefore, the advertisement dated 7/7/2024 published by the Principal Director, Directorate of Health and Family Welfare, Nagaland, Kohima, is bare in law and therefore stand quashed. So the first advertisement is already quashed, your lordship.
Yes.
Now, the direction. Accordingly, the state's respondents are directed to publish a fresh advertisement where it shall mention amongst other conditions, your lordship, regarding eligibility, that the landowner or their family members shall be given preferential treatment, your lordship. Pausing here for a minute, your lordship. The direction doesn't end there. It doesn't say that among other conditions regarding eligibility, that the landowners or their family members shall be given preferential treatment. It doesn't end there. It says, if otherwise found eligible for appointment. Had it stops there, as it ends there, your lordship, the case would have been different. But there's another direction, that is, if otherwise found eligible for appointment.
Okay.
So that means, your lordship, from among the open advertisement made, if the petitioner is found eligible on the basis of a land ownership, then preferential treatment should be given to him from the open advertisement.
So how were they not eligible?
Yes, your lordship, I'll explain that, your lordship. From an open advertisement. I just wanted to make my lordship note this. From an open advertisement.
Okay.
Now, your lordship, in compliance to this honorable court order, again another advertisement was issued dated 5th of March 2025.
Yes.
Wherein at para 7, now the condition has been prescribed. Your lordship will find it at page 73.
Yes, that same.
Yes,
Condition.
more or less same thing. Only that amount, whereas clause 7, among other conditions regarding eligibility, that the landowners or their family members should be given preferential treatment if otherwise found eligible for appointment. Now, your lordship, the petitioner at no point of time have challenged this. They have at no point of time challenged this, your lordship. In fact,
yes.
accepting the advertisement, the petitioner said for the interview. Now, your lordship. Now, your lordship, in the advertisement, that is 5th of March 2025, if my lord can kindly see clause 4, I may be allowed to read this.
Yes.
Applications should reach the Directorate of Health and Family Welfare, Nagaland, Kohima, on or before 21/3/2025 in the establishment section during the office hours. Interview, your lordship, see. Interview will be conducted on 26/3/2025 from the Directorate of Health and Family Welfare, Kohima, Nagaland, starting from 11 a.m. Mention clearly that interview will be conducted. Had the petitioner been aggrieved that only interview is conducted and no written examinations are to be conducted, and if they are aggrieved by it, your lordship, they should have challenged this then. If the submission of the petitioners that without
Yes.
without written examination, how can the merit be determined by way of an oral interview only? If that is the case, and if they agree by that, your lordship, then they should have challenged this. They did not, your lordship. In fact, they accepted it, and they have appeared in interview, your lordship. Now, your lordship, after appearing in interview and after being not successful, they are here before this court. And what are they challenging, your lordship? They are challenging the meeting minutes, your lordship, at page 157.
Yes.
At page 157. This is the selection process. Now the question is, Your Lordship, after appearing in an interview, failing in an interview, can an applicant approach this honorable court challenging the selection process, Your Lordship?
But were they eligible? They were eligible, isn't it?
Your Lordship, all the candidates,
Yes.
all the candidates who were found eligible to appear for the interview, they were allowed to appear for the interview. Now, Your Lordship, that is why I was saying open advertisement. Now, in an open advertisement, Your
So
Lordship,
if they are found eligible,
yes,
the order of this court is that they should be given preferential treatment.
yes. And how should it be? How should the preferential treatment be given, Your Lordship? That is not mentioned. So, in an open advertisement, Your Lordship, in an open advertisement, how should a candidate be selected?
No, if preferential treatment means if they are found to be landowners,
Yes.
genuine landowners,
Yes.
then extra marks also could have been given.
No, Your Lordship. Then in that case,
Preferential treatment.
Your Lordship, preferential treatment has to be from among the equals. Yes, and then on merit, equal marks obtaining on merit, Your Lordship. And therefore, in the affidavit, we are taking the ground that, look, if a general candidate who is not a landowner and a candidate who is a landowner, if they score equal marks, then yes, preferential treatment as directed by this honorable court should be given, and in that circumstances, the person who is a landowner should be appointed.
Okay, so according to you, only when they both secure equal marks,
Yes,
the general and the landowner, then
Yes.
the landowner will be given the preferential.
preferential treatment, particularly when it comes to an issue where there is an open advertisement involved, my lord. Preferential treatment, Your Lordship. Preferential treatment cannot be interpreted in a way that even if there is a direction from this honorable court that I should be given preferential treatment, it doesn't mean that I will fail terribly in the exam and still should be considered as as a successful candidate on the ground that preferential treatment should be given. It doesn't mean that, and it cannot be interpreted that way, my lord. Now, Your Lordship, if that interpretation is to be considered, then Your Lordship, then the direction of this honorable court, in its order dated 12/2/2024, directing the respondent to initiate fresh process for filling up the vacancies is defeated. Because it says, Your Lordship, in the order it says, the state respondent shall now initiate a fresh process for filling up the vacancies in a district hospital by inviting applications from all interested and eligible persons. Then preferential treatment, Your Lordship. Even if a landowner failing, yet preferential treatment has to be given to him. If that is to be considered, then Your Lordship, the order passed by this court directing the respondent authorities to initiate a fresh process of inviting applications for filling the post from all the interested and eligible persons is defeated, my lord.
Then how do you reconcile this with the OM dated 16 August 2018?
Your lordship, the OM and the
As per the OM, there is no need for an interview even.
yes,
Oh.
yes, there is no need. Therefore, Your Lordship, once this order has been passed by this honorable court, the petitioner should have challenged it. Here is the case where that particular concern post which are there in the present petitions. These are the posts which has been directed by this honorable court to the respondent department to advertise it. So if at all, the landowners are to be appointed against this particular post, Your Lordship, and then the prayer of the petitioner is that in this present petition, then in that case, Your Lordship, they should have challenged
So
this.
in the first place, why didn't the petitioner say that there should have been no interview?
Chip, the issue is this, the simple issue on the question of interview. I'm only making a highlight. I'm only bringing to the notice of this honorable court that the subjective nature of the interview, only
No,
for
no.
that purpose.
When a direction was given for the interview,
No, Chip.
the petitioners could have
My
challenged
lord,
that.
the point is this
Yeah.
direction was given to conduct the interview in terms of the OM.
In terms of the OM, dated
Yes.
16 August.
Yes.
But this doesn't envisage any interview. This 16
lord,
August 2018.
That I agree. That I agree. But keeping in view, with due respect, because Your Lordship may kindly appreciate the fact under what circumstances this direction was given by the learned single judge. The learned single judge, keeping in view the judgment of the Honorable Supreme Court in Gauhati and others, and to come out with a harmonious construction. The judgment which I am relying upon has come with a direction that you conduct an interview in terms of the OM and give preference. So the process, the normal, so that was the direction. That was the direction.
I think the petitioners should have challenged that direction
My lord,
in an appeal.
Correct, correct.
my lord, whether I challenge
Because that is not in consonance with
lord,
the OM.
the point is
Correct.
this. The point is this.
Hmm.
The point is this. Direction has been given. My lord, this judgment, direction is given. I have not challenged. There is no issue. I have not challenged it. No writ appeal has been filed. But again, from the other side of the coin, whether the direction given in the judgment has been strictly implemented while implementing the judgment, I'm only on that point. Yes, I have not challenged. Whether I should have challenged or not challenged, that's a different issue. But in the present case, the subject matter of this present case is I'm challenging before this honorable court whether conducting the interview, whether the interview was conducted strictly in terms of the direction of this honorable court and condition number 7 of the judgment, of the advertisement.
No, but when this court already said open advertisement.
Yes.
Then other general candidates will also come in.
Fine.
Then the normal procedured rules of the interview has to be followed.
My lord, what?
And
But the point is,
situation may arise if we go by your submission. Then all the posts will have to be given to
My
the
lord,
landowners.
but that is a direction.
What's the point of having an
My lord,
interview then?
My lord, that is the direction of this honorable. I'm not challenging of this court. I'm not challenging the wisdom of the 3 judgments. Lordship may kindly appreciate the fact it is not only judgment, 4 judgments. Repeatedly, consistently, that judgment has been given and implemented by them. If they have not implemented, then the question of not appealing would arise. But on the one hand, they have implemented the judgment and given preference. Interview was held for in 123 and appointment given to the landowner. So why the same yardstick is not followed? That is the issue. If
In 122 and 23,
yes,
only landowners were appointed.
Your Lordship, in 122 and 123, Your Lordship, what happened was there was a clear-cut direction from this honorable court that preference should be given.
yes,
There was a clear-cut
So
direction.
here also,
Yes.
it should be given.
Yes.
Same.
Yeah, but there was open advertisement issue, Your Lordship. Here in this case is little different, Your Lordship.
there
No.
advertisement was there. See the
In
judgment.
that 122, 23 also, it
It
appears
is
there was an
That, Your Lordship, in that case,
advertisement.
in that case, Your Lordship, look, once the open advertisement has been given, if that is the case, they should have challenged the advertisement itself, Your Lordship.
Not in a part of that case, they have already implemented.
No, I mean this
That-
advertisement,
that-
this particular advertisement. Yes. Now, Your Lordship, if that is the case, what will happen to the successful candidate then? For appeared interview.
That's why I'm saying it'll come, a situation will arise where only the landowners will
My
get.
lady, my lady, we can appreciate this fact. Going by their submission, why I have not challenged. On that point I'm making, the other general candidates also had appeared in the interview, knowing fully well that condition number 7 is there. That if they are landowners and they are eligible, all of them, all posts may be filled up by the landowners. That condition is already there, and without any complaint, they have taken a chance and applied. So the same yardstick applies to me and them.
It only says preference. So if
But the
they
issue is
score,
this, the issue is this, only it says preference. From the statements, from the meeting minutes, it is one of my condition, whether at all the interview board has taken into consideration condition number 7 in the meeting minutes, during the interview. I made a submission that nobody has asked me whether I'm a landowner, whether I have genuinely donated. That was never inquired, admitted by them. And in the meeting minutes.
no, if equal marks had been secured by you and one of the general candidates, then they would have asked, among you, who is the landowner?
My lord, my respectful submission
But
is,
when your marks are
my respectful submission is the conditions at item numbers, the condition 7 should be read as a whole, not in isolation. And it applies both ways. It applies both ways. It should not be read in isolation.
Anyway, please continue.
Your Lordship,
Yes.
and therefore, if that submission of the petitioner is taken into considerations, that preferential treatment is there. So even if, no matter whether I fail or not, I should be given preferential treatment, then, as I said, Your Lordship, the order of this honorable court directing the respondent to issue an open advertisement is defeated, Your Lordship, if that is the case. But here, Your Lordship, not only that, here there is another issue, Your Lordship.
Yes.
Yes, Your Lordship. So my submission is that the first submission is that then in that case the order of this court is defeated. Secondly, Your Lordship, as with regard to the submission made by the counsel for the petitioner with regards to the oral interview, that was clearly projected in the advertisement. They have no grievances to it, and they have appeared in the interview.
Yes, then.
Now, Your Lordship, this is a clear-cut case where the petitioner silently appeared in the interview and failed, Your Lordship. The question is, had they been successful, Your Lordship, would they still come back to this honorable court and say, look, such criteria has to be done, has to be followed, but that criteria was not there. So even if I'm selected, my selection is wrong. They cannot come back and say that, Your Lordship. And therefore, after appearing in the interview, Your Lordship, can a person have any right to approach the honorable court challenging the interview process, Your Lordship? I will place my submission on the citation, Your Lordship. 1995 3 SSC, Your Lordship.
Regarding that, there are so many
Yes.
attachments. But whether that principle of law will apply in the present case or not, that also we have to consider.
Your Lordship, it is a clear case, but they are challenging. You look at the prayer, Your Lordship. Prayer at page 27.
Yes, para.
Prayer at page 27.
Yes.
Oh, the judgment, Your Lordship, yes.
Their prayer.
Yeah,
scene,
yeah. Para 9 and 10.
They are challenging the interview process.
Yeah, then in challenging the interview process, which means the selection process, they are challenging, Your Lordship. And so at para 7 of the case that I have just referred to, my lord, para 9, page 493.
Yes.
I may be allowed to read this, para 9 and 10. Before dealing with this contention, we must keep in view the silent facts that the petitioner, as well as the contesting successful candidates, being respondent concerned herein, were all found eligible in the light of the marks obtained in the written test to be eligible to be called for an oral interview. Up to this stage, there is no dispute between the parties. The petitioner also appeared at the oral interview conducted by the members concerned of the commissions who interviewed the petitioner as well as the contesting respondent concerned. Thus, the petitioner took a chance to get themselves selected at the said oral interview, only because they do not find themselves to have emerged successful as a result of their combined performances both at the written test and the oral interview. They have filed these petitions. It is now well settled, Your Lordship, this is important. It is now well settled that if a candidate takes a calculated chance and appears at the interview, then only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of interview was unfair or the selection committee was not properly constituted. This is what the submission is, Your Lordship. In the case of Om Prakash Shukla versus Akhilesh Kumar Shukla, it has been clearly laid down by the bench of 3 learned judge of this court that when the petitioner appeared at the examinations without protest, and when he found that he would not succeed in examinations, he filed a petition challenging the said examinations. The High Court should not have granted any relief to such a petitioner. Para 10, Your Lordship, I'll refer just only 3 lines. Para 10. Therefore, the result of the interview test on merits cannot be successfully challenged by a candidate who take a chance to get selected at the said interview and who ultimately find himself to be unsuccessful. So he cannot, applicants cannot come back and challenge the result, Your Lordship, after he has appeared or after she has appeared, my Lord. This case clearly covers the instant writ petitions, my Lord. I raise my submissions. I'm deeply obliged.
Lordship, I'm aiming for a selected candidate, that is private respondent number 8, 9, 10, and 11.
9, 10.
The main issue raised by the petitioner in the present writ petition is that in the advertisement which was issued in compliance to this honorable court, a preferential treatment should be given to them. And that was not extended to them. That is the main condition. In Lordship, regarding the confusion, how in view of the office memorandum of 2018 issued by the state government, no interview is required for appointment of landowner. But how in the present case, the interview came? Lordship, in order to clear that confusion, Lordship, in the first round of litigation, that was in the year 2023, WPC 19.
The WPC 19.
Page 7. No, page 51.
Yes, starting from 51.
Lordship, my little senior friend has already read out some of the paragraphs, Lordship. And as per the paragraphs which my little senior friend has already read out, he has already highlighted that it was the case of the petitioner that the parent villagers exhibited 2 agreements for giving some benefits to the landowners. And that was, and since as per that agreement, they were not given the chance of appointment on landownership. They filed that earlier writ petition, that is WPC 19 to 22.
22.
That's Lordship. And Lordship, in that case, Lordship, kindly come to page paragraph number 12. Lordship, my learned senior friend has already read out up to paragraph 7. That is the stand of the petitioner. Lordship, it was a stand of the state respondent in that writ petition. Paragraph 12. Paragraph 12, page 61.
Yes.
The learned state counsel, Mr. So-and-so, by referring to the affidavit of opposition filed by the state respondent, submits that, in fact, landowners have been given credit for appointment from time to time. That was a stand of the state respondent. In support of his submission, he refers to the annexures appended to the annexure affidavit of opposition in the WPC number so-and-so, wherein, in the birth certificate of the appointees, appointees concerned. The place of birth has been shown to be Pirin village. Also in the affidavit, a certificate testimonial certifying the appointee to be a native of Pirin village and landowners issued by the Pirin village council and also has been annexed. He therefore submits that the claim of the petitioners that none of the landowners have been appointed to create 4 posts is not correct and only misconstrued. So that it was a stand of the department that the landowners have already availed the benefit of grade 4 appointment. And Lordship may come to para 18. From para 17, it is an observation in the findings of the learner single charge. Lordship, the more relevant is para 18. Para 18, page 64 also.
Yes.
The petitioner in the instant case have relied upon the OM dated 16/8/2018. That is a standing OM, wherein the manner of consideration for providing employment to landowner have been provided. And also with the clarification that such employment cannot be provided in perpetuity. So that the learner single charge worship has already considered the condition which has been prescribed under OM of 2018 worship. And after considering all the materials available in the writ petition, Lordship, the learner single charge is finally directed in paragraph 20 to consider to go for a free selection by inviting all interested and eligible persons. So, Lordship, the present writ, they were the writ petitioner and the run of litigation. It was your case for consideration of your case for appointment under the 2018 OM. That was not allowed by this noble court. If that was allowed, the direction to conduct a free selection by inviting all applications by issuing advertisement that directs. Your claim for consideration under 2018 OM that was not considered, and now the direction has come for to fill up the post by issuing an advertisement.
What was there?
In the earlier round of litigation, there were 5 writ petitions.
So in this WP 70, I mean the first one,
WPC 19.
WP 19,
Yes, ma'am.
the petitioners challenged an interview as an advertisement.
No, they have not challenged the advertisement. They have challenged only the appointment of the
Private
next
respondents
problem.
and claim for
Claim for
appointment
the
on
consideration of the case
on
in terms of that
learner
2018 OM. That was a priority in the writ petition. Now, should be in compliance with the direction passed by this honorable court on 12/2/2024.
That's why I'm saying the petitioners after WP 19 should have challenged this direction. That's what I'm saying.
If you want to
Because
to be considered your case without any selection. Lordship, they have not challenged this direction, and now the in compliance with the direction passed by this report, the advertisement came. The first advertisement they have challenged. And now, Lordship, in subsequently in compliance with the direction passed in WBC number 160, that the present advertisement came. And Lordship, my learned friend, they have already read about the condition which is prescribed in serial number 7 in the advertisement dated in the month of March 2005. Lordship.
yes.
As per this condition, the landowners to be given preferential treatment. Lordship, in order to avail this preferential treatment, Lordship, I mean, allowed to take your Lordship to the marks secured by the petitioner in the private respondent. Lordship, we come to page number 157.
Yes.
Lordship, we come to serial number 11, Kulupu Rinda.
You got 25.
Kulupu Rinda, Lordship, is the private respondent number 10.
Mm.
And Lordship, we come to serial number 30, Changbu Jin.
30.
Is the private respondent number 11, Lordship.
This is respondent 11.
And Lordship, we come to serial number 63. 63, the private respondent number 9, Akim Hiri. And Lordship, we come to page number 165, serial number 131. Keating.
131.
No, Keating is not your.
He's a landowner.
Yes, Lordship.
Yes. I think it's serial number 20, page 167.
Lordship, we come to page number 168. That is for the post of life attendant, is serial number 17. Is the respondent number 8.
This is respondent 8.
And in the present petitioners, your name figures at serial. Lordship, we come to page number 165.
129.
129, 130. And Lordship, we can see the marks secured by them. One secured 17 and one secured 18.
Petitioner 1 is 17.
Billing long hiki, yes, sir. And once Lordship, we come to page number 167, serial number 20. Key round to be. He secured 20 marks. Which was 8. Then we come to page number 168.
168.
Cell number 23. Inko Holy. Lordship, we scored the 13 marks. Lordship.
That is petitioner number 4.
And Lordship, if we compare the marks secured by the present private respondent in the present brief petition, it is a huge difference. Lordship, the law on this preferential treatment, this has been already laid by the apex court in several judgment, Lordship. And one of the judgment, Lordship, it emerged from in the year 1996. Lordship, I'm relying on 1996, volume 6, SEC.
1996.
282, Lordship.
2.
1996, 6 SEC, 282. Lordship, in order, Lordship, the facts is also important in this case, Lordship. So, I mean, I'll to read one paragraph in the facts. Para 3, Lordship.
Yes.
Respondent number 1 filed a writ petition challenging the selection made by the Punjab Public Service Commission for the post of dental officers in their area on the ground that the selection had been made arbitrarily and is contrary to the positive term of the advertisement, indicating preference to be given to higher dental qualification. It was pleaded before court that an advertisement had been issued in the newspaper on so-and-so for 12 posts of dental officers, all of which 12 were meant for general category, 5 for is scheduled tribe, scheduled guests, 2 for backward classes, and 2 for ex-servicemen. It is stipulated in the advertisement that preference ought be given for higher dental qualification in the minimum qualification for the post was PDs. Respondent number 1, who had the qualification of MDs, claimed entitled to be selected on the basis of higher qualification. It was also pleaded that the Public Service Commission acted arbitrarily in awarding 20 marks out of 100 marks for verbal vice, 20 marks for general knowledge, and only 2.5 marks for higher qualification. The private respondent who contested the proceedings filed their counter affidavit stating therein that in the absence of any statutory rules governing the mode of selection for the post of tenure officers, an expert body like Public Service Commission had awarded different marks and evaluated the respective merit of all the applicants and finally selected the meritorious one, and therefore it cannot be said to be arbitrary. It is also urged that the selection thus made by the Public Service Commission is not amendable to the jurisdiction of the High Court. The division bench of the Punjab and Haryana Court came to hold that under the advertisement in question, person having higher qualification of MTs form a class by themselves and therefore they are entitled to be selected for the post on the basis of their qualification in the Public Service Commission acted against the spirit and intent of the appointing authority who had laid down the minimum qualification for the job and indicated preference for higher qualification. That was the issue in that case also. By referring to the meaning of the expression prefer in different dictionaries, the High Court also held that such persons having professional qualifications are entitled to be selected and appointed, unless they are otherwise held to be not suitable. The High Court also further came to the conclusion that the awarding of different marks by the Public Service Commission is arbitrary and irrational. With this conclusion, the writ petition having been allowed in Public Service Commission have been directed to forward the name of the respondents. The state has come up in appeal. Which is the findings of the Apex Court in paragraph 7. Admittedly, in the advertisement which was published calling for application from the candidate for the post of tenure officer, it was clearly stipulated that the minimum qualification for the post is PTs. It was also stipulated that preference should be given for higher tenure qualification. There is also no dispute that MGs is a higher qualification than the minimum qualification required for the post, and respondent number 1 was having that degree. Which from here is important. The question then arises is whether a person holding a MT's qualification is entitled to be selected and appointed as of right by virtue of the aforesaid advertisement conferring preference for higher qualification. The answer to the aforesaid question must be in the negative. When very important. When an advertisement stipulates a particular qualification as the minimum qualification for the post and further stipulates that preference should be given for higher qualification, the only meaning it conveys is that some additional weightage has to be given to the higher qualified candidates. But by no stretch of imagination, it can be construed to mean that a higher qualified person ultimately is entitled to be selected and appointed. In the remaining paragraph that is regarding the evaluation of marks, that is not reviewed. And by following the principle which is laid down in this judgment, there's another judgment which was passed in the year 2002. 2002 for ACC 16.
2002 for ACC
16.
16.
Bishop here that the submission which my learned friend Mr. Niu has already submitted that it will be projected here. Para 12. Preference can be extended only amongst the equals.
16. 16. Okay.
Para
Ibu Data Mohanty.
Yes, project.
Para 12.
Ibu Tata Mohan. Para 12.
Yes.
Is she married?
Please read.
Admittedly, in the requisition sent by respondent number 4 to the employment exchange, candidates having 8 class pass qualification were called for consideration. And accordingly, the employment exchange is sponsored as many as 40 candidates, all 8 class pass. It is true that The guideline contained in the method of recruitment mentioned that the minimum educational qualification is 8 pass and preference will be given to ACC pass.
Preference will be given to SCC pass. Okay.
But the requisition did not specify that preference would be given to ACC pass candidate. Had the four respondent noticed that this condition, perhaps the employment exchange would have also sponsored ACC pass candidate as well. As the basis of selection was in terms of requisition to the employment exchange, the selection authority has committed no illegality in not giving preference to ACC pass candidate. That was a fact. But how the preference will be given, that is in the remaining paragraph. However, the preference clause for higher qualification does not mean that irrespective of fulfillment of other norms, ACC pass have to be preferred. When any rule or guideline provides preference in respect of some higher qualification, they are claiming for preference on the basis of line ownership. It only means that all other requirements being equal. Admittedly, in the present case, there was a selection. In the selection, if they score the equal marks, in that case, they can be considered. A person possessing higher educational qualification will be preferred. It cannot, however, be considered as the sole criterion for preference in selection and appointment. In matter of selection and appointment, that is a law. And applying the same principle in a recent judgment that was passed in the year 2019. 2019 6 ACC 362.
Para?
From Paranay din si Bono written yes from para 13 ownership. In this case, there was a condition for the preference in the advertisement.
13.
Para 13.
The preference clause. Yes, please read.
The preference clause in clause 4.7 only meant that if a candidate with the required degree qualification and practical experience in the manufacturing and testing of drug for stipulated period of years has an additional desirable attribute of a research experience in a research laboratory. Other things being equal, preference could be given to such a candidate. The preference mentioned in the advertisement cannot be interpreted to mean that merely because a candidate may have had the requisite experience of testing in a research and development laboratory, she possesses essential eligibility and had the preferential right to be considered for appointment. In the paragraph 4, here they have reiterated the judgment which was passed in the year 1996. So I'm not referring to that. So Lordship asked, admittedly in the present case, there was a selection. And in the selection process, if we compare the marks secured by the present petitioner and the private respondent, this is a huge difference. So the preference clause, which has been incorporated in the advertisement, that cannot be extended to them. And so they should not have any grievance in the present case. One of the submission which the petitioner has brought before this court was that there was only an oral interview, and by the oral interview, the merit cannot be tested. That was
one of their.
Lordship, in order in reply to that, Lordship. Lordship may come to the advertisement that is in page number 73.
Yes.
If we see the condition number 4, the condition number 4, it specifically provides that
Interview.
interview will be conducted in so. And Your Lordship, after the present selection was made, the present petitioners, they have submitted respective representation. And in one of the representation, that is at page number 94. Page number 94, this was submitted by Bilingrang Hikyu. Lordship, may come to page number, the next page, that is page number 95.
95.
Third para. Lordship, got it? Third para?
I have
had answered, Lordship. I have had answered all the question appropriately and properly as per the question without any mistake. Written exams, which is important. Written exams were not conducted by the department since it is only a grade 4 post. When they have submitted a representation before the appropriate authority, when they have taken this stand, now they cannot turn around and take another stand before this rule book.
page 95. Yes.
So, it was a selection process. When as per the selection, as per the advertisement which was issued in the present case, that there was a clear direction that only interview will be conducted. And the condition which has been prescribed in this advertisement is not a challenge before this. So they cannot question this question. And Lordship, one of the submission which my little senior friend has brought up, the present the present board, we just conducted an interview. That was in violation of the OM dated OM of 2016.
Yes, yes.
That is one of the conditions.
Board constitution.
Yes, Lordship.
Yes.
Lordship, regarding this OM of 2016, Your Lordship may come to paragraph 2
Petition.
in the read petition. Read petition, para 2.
Yes.
If we read from the 7th line.
Yes.
7th line. The office memorandum number so and so, dated 7/12/2016. Issued by the Chief Secretary Nagaland had laid down that all direct recruitment in grade 4 posts and district office of the department shall be filled by indigenous inhabitants of the respective district. This is the only grounds which they have taken in the present read petition with regard to this office memorandum of 7/12/2016. Nowhere in the read petition they have stated that the present recruitment was done in violation of this office memorandum. So a strip of facts which is not plated in the read petition, that should not be allowed to be urged by this rule portion. And we come to paragraph 17. Para 17 in the read petition.
17. Yes.
This is a statement. That the petition states that in the particular facts and circumstances as stated above, it is respectfully stated that when the petitioner appeared to oral interview on so and so, they were under the full impression and belief that the interview board shall be conducting strictly in accordance with the standing guideline, orders of this honorable court in the condition stipulated in the advertisement that is so and so. It has come to the knowledge of the petitioner that the interview board in the respondent already acted in clear violation of the standing guideline, order of this honorable court in the condition stipulated in the advertisement that is so and so. except the condition that it was in clear violation of the standing guideline. Which standing guideline? That is not been specified in the entire pleadings of the writ petition. If you want to make out a case with regard to the violation of this office memorandum of 2016, there should be a specific pleading before this honorable court that the selection was done in violation of this office memorandum of 2016. So facts which is not pleaded before in the writ petition, that should not be allowed to be urged. That's all, my message.
Lordship,
Yes.
I will take 2-3 minutes only pointed clarifications. Firstly, Lordship, my learned friends were making a submission that we are all equals, and since we are all equals on the measures of the marks performance in the exam, it has to be decided. My respectful submission, we are a class apart. We are not equals. I am a landowner who has donated land free of cost. We are not landowners. So we are a class apart. That is my first submission and the question to
But
equality.
when there's an open advertisement, then I don't know that land
Why not?
ownership.
Because the question is, Lordship, ultimately it goes back to condition number 7, landowners. So I'm a landowner, you're not landowner in terms of the conditions stipulated in the advertisement. So I'm a class apart.
It
In
only
terms of-
says preference.
My lord, eligibility and preference. I will come to that. I'm coming to that. Because the judgment which I have relied upon, in fact, it will support me. I'm coming to that. One, on the question of eligibility, on the question of equality, that I'm a landowner, they are not landowners. In terms of condition number 7 of the advertisement, my lord, I'm a class apart. That is with regard to on the contention of equality. Secondly, Lordship, on the issue of oral interview, repeatedly they have been making strong submission on that. Subject to repetition, I have been saying that I am highlighting about oral interview just to highlight the subjective nature of the interview, not being objective. Thirdly, Lordship, my learned friend has relied upon paragraph 18 of the judgment of 2019, where the state government had taken a stand that we are not landowners. That is, so to that extent, my RTI reply, 9/4/2014, which I have highlighted that so
No
far
landowners.
nobody has been appointed on the basis of land ownership. RTI reply was 9/4/2024. Finally, the judgments. Now, thirdly, the question is, my lord, whether I should have filed an appeal. That repeatedly that issue is raised. My simple answer, Lordship, if my lord may kindly see the judgment, 160. The first judgment was WPC 122 of 2019.
Yes.
So as early as WPC, as early as 2019, Lordship, page 69, and 70.
That's the second one.
Yes, this court in WPC 122 2019, page 69 on the bottom, passed a direction stating that whenever a state publishes any advertisement inviting applications for filing grade 4 posts, it has to be mentioned in the advertisement itself that landowners or referendum members of the shall be given preferential treatment. So as early as 2019, that judgment was there. Then, Lordship, 123/24, they have already implemented. So why double standard? That is what I'm questioning. If they have not implemented WPC 123/2024 judgment, then I could have, then to say that I have not filed a writ appeal would have come into play. But when they have already implemented the judgment, why not me? Why the discrimination? Finally, Lordship, my learned friend has relied upon Honorable Supreme Court judgment of 1996, 6 SEC. And the two judgments which has reiterated that. My lord, may kindly read the judgment because I'm aware of this 1996 judgment. Because it talks about, my lord, preferential treatment giving weightage. In fact, in the advertisement, in the marks, weightage was a provision was there to give weightage to the higher qualification. If, my lord, in 1996, 6 ACC, when the mark was distributed, a certain percentage of weightage was given. Certain percentage was reserved for higher qualification, weightage was
To the
given.
ones with higher qualification.
Yes. They came to the court, saying that, challenging everything, that without weightage, nothing. Since they have the qualification, they should be given. But the court said that preference means certain weightage should be given. Here, no weightage whatsoever. So my lord, the ratio will not apply. Secondly, lordship, in all the 3 judgments which my learned friend has relied upon, it is talking about preferential treatment. My lord, it is talking about preferential treatment. In this case, lordship, it is not only preferential treatment, but in the present case, the conditions number 7 is preferential treatment if found eligible. So preferential treatment was qualified with the word found eligible. Much applied. So that way the ratio of this case will not apply, because if it is only preferential preference alone, then this judgment will apply. But here, but in this present advertisement, preference if found eligible. So the word eligible is missing in the 3 judgments. If found eligible is missing in the 3 judgments. Much obliged, lordship.
Third counsel, senior counsel, Mr. Takamasa, assisted by Mr. Sentilo for the petitioners. Also heard Mr. Senior Government Advocate, Mr. Enangami for the state respondents, and Mr. Limawapang for the private respondents.
8, 9, and 11.
8, 9, 10, and 11. Hearing concluded, order reserved.
Much obliged.
You just give me printouts, okay? Printouts.
For admission, item number 4.
Yeah, printouts. Yes, why has this come?
My lord, I've already filed affidavit on behalf of state, my lord.
Yes, would you like to file any reply or pleadings are complete?
To file a reply will be given time.
Okay, heard, learned counsel for the petitioner, Miss such and such, stop. The learned government advocate, Mr. Tiba Apom, submits the affidavit in opposition on behalf of the state respondents has been filed. Stop. The learned counsel for the petitioner prays for some time to file a reply to the affidavit of the state respondents. Stop. Accordingly, wait, how much time do you want?
3 weeks.
Accordingly, please the matter of the 3 weeks in order to enable the learned counsel for the petitioner to file a reply to the counter affidavit.
Much obliged.
For admission from the supplementary cost list, item number 18.
This is for admission hearing.
Your Honor.
Hearing.
Admission.
Can we list it on another day? Actually, I'm having some problem with my eyes, and I need to rest my eyes a bit, and I've got already 4 or 5 CAVs pending. Can we list it next week? Is there some urgency?
No, Your Lordship. Your Lordship, yes, after 3 weeks, Your Lordship.
After 2 weeks, you.
Not next week.
No.
Okay. You just say due to paucity of time, list the matter for admission hearing after 3 weeks.
Okay, much obliged.
The other matters also, are the councils ready? Hearing matters.
Lordship,
Item 12, 13, 14,
12,
15.
13, 14, 15, yes, they're analogous matter. However, Your Lordship, by seniors on legs, hearing has started and it will take some time.
Mm.
So
next week?
any date convenient to,
Lord, is it convenient for the court to fix this matter on 18/5?
18.5. Okay, no problem. Learned counsel for the petitioner, Mr. I. Jamir, submits that for the respondent submits that the leading counsel, your petitioner submits that the leading counsel, Mr. T.B. Jamir, is on legs in court number 2. Accordingly, prays that the matter may be listed on after 2 weeks. That will be after 2 or 3 weeks.
almost 4 weeks, because today is 21st.
Just say after 3 weeks. So in the meantime, the learned CGSC, Mr. B. Deka, prays that the matter may be listed on 18/5 as he is an outstation counsel. So the prayer is allowed, list on 18/5 for hearing. Yes.
No, I apologize, my lord. I made a mistake. I should have stood on the other side.
Yes, that's why I was. It should have been. It should have been
confused.
Yes.
I'm extremely sorry, ma'am.
It's okay. It's okay.
Obliged.
Yes. Then item 7.
Mr. Lordship, we have just received the instruction copy from the ministry just yesterday. The copy of the instruction from the ministry
Okay.
just yesterday. If I may be allowed to serve the copy to the
Do
court.
you want to file a counter or just
Lordship will be filing the
produce the
counter.
instruction?
The counter.
It's on the
However,
basis.
yeah, yes.
It's better you file in the form of affidavit, isn't it? Your instruction,
Mr. Lordship.
instead of just placing it.
However, it has been reflected in the instruction that we have been asked to take time to file the affidavit.
Asked to take time. Learned counsel, Miss such and such, appearing for
Ilivioso, the union petitioner.
Okay. Appearing for the petitioner submits that she has received instructions from the petitioner to seek further how much time?
3 weeks time.
Further 3 weeks time to file the affidavit in opposition. So the learned counsels appearing for the respondents. Who's appearing for the respondents?
My lady, I'm representing respondent number 1.
They are praying for 3 weeks time.
There's no objection, Your Honor. My lord.
No objections. List the matter after 3 weeks as prayed for by the learned counsel for the petition. Yes.
Much obliged.
Much obliged.
Another,
19.
any more?
19. Something.
19, oh yes. 19.
For hearing.
What about item 19? Can we, I'm having some problem with my eyes.
Very well.
And I've been asked to rest my eyes. How can I rest? Can we list it next week?
Can I look at a date you wish?
Yes. 27, 28.
It's this week, May, first week, 2, then 18 of the first week, that's an see. Exact time, yes. Can it be on the 11th May?
11th May.
This end of the month and first part of May, we have all those exams coming up for our children. So
Okay. I'll just say due to paucity of time. Okay.
yes.
Due to paucity of time, the matter could not be taken up. List on 11th May for hearing.
Very good. Much obliged.
Plus, because disposal statement Sixteen, okay. 16.
Okay,